The Honourable Minister of Finance.
Mr. Speaker, I'm pleased to voice my support for Bill C26, the Tougher Penalties for Child Predators Act, during third reading debate. This is critical legislation that addresses concerns that I believe we all share. Bill C26 reflects the ongoing efforts of this government to combat all forms of child sexual exploitation and denounce the grave and reprehensible nature of such heinous crimes. The bill is another concrete example of our commitment to protect Canadian families, communities, and above all, to protect the most vulnerable and valuable members of our society, our children. Mr. Speaker, we know that children are particularly vulnerable to sexual abuse and exploitation and are far more likely to be victims of sexual crimes than are adults. While violent crime rates are trending downward in Canada, it is very worrisome that the number of child sexual offences reported to police continues to rise. In 2013, police reported some 4,200 incidents of sexual violations against children, a 6% increase in the rate from the previous year. As noted by Statistics Canada in its report on police-reported crime, released in July 2014, sexual offences against children was one of the few categories of violent crimes to increase in Canada in 2013. I think we can all agree that these numbers are a cause for concern. And let me assure you that the troubling reality behind those numbers is exactly what the Tougher Penalties for Child Predators Act aims to address.
The proposed criminal law reforms in Bill C26 are targeted at deterring these horrific crimes, ensuring that offenders are held accountable for the harm they cause to children, and enhancing our ability to monitor these offenders to assist in preventing recidivism. More specifically, Bill C26 proposes to increase mandatory minimum penalties and maximum penalties for many child sexual offenses. For example, Bill C26 would ensure that maximum punishment for all hybrid sexual offenses against children would be 2 years less a day for a summary conviction and 14 years on indictment.
26 also proposes to increase the penalties for making and distributing child pornography, as well as to make these offences strictly indictable to better reflect their seriousness. Child pornography offences can have long-lasting and devastating impacts on victims, particularly when images and videos are posted on the internet. Once on the web, child pornographic images can quickly be disseminated around the world and might be accessed indefinitely, with the result of re-victimizing the child victim at every click. Mr. Speaker, this bill would also ensure that committing a child sexual offence while on a conditional sentence order, parole, or statutory release is considered an aggravating factor for sentencing purposes to assist in preventing future offences by convicted child sexual offenders. Bill C26 proposes to increase maximum penalties for violations of prohibition orders, probation orders, and peace bonds. Canadians are rightfully concerned about the mobility and conduct of known child sexual predators once they are released into the community, and stricter measures are needed to ensure that supervision orders are observed and breaches of conditions result in appropriate consequences. These conditions, which may include refraining from being in contact with a victim, staying away from a specific household, or prohibitions around the use of weapons, alcohol, or drugs are imposed to protect the children. A breach of these conditions generally means that there is an increased risk that the offender may commit further sexual offenses. Therefore, Bill C26 would increase the maximum penalties for breaches of conditions of any of these orders from 6 to 18 months if preceded by summary conviction, and from 2 to 4 years if preceded by indictment. Mr. Speaker, Bill C26 not only sends a strong signal that the protection of children is a paramount value of Canadian society, it also communicates the important message that every victim matters. The reforms in Bill C26 would also amend the Canadian Evidence Act to ensure that spouses of individuals accused of child pornographic offenses are compellable witnesses for the Crown. The testimony of an accused spouse may be required to facilitate the prosecution of a child pornography offense when the pornographic material is found on a home computer, for example. Cependant, les modifications.
But Bill C26's criminal law reforms do not stop there. To further address the risk posed by child sexual offenders, Bill C26 proposes amendments to the Sex Offender Information Registration Act to require registered sex offenders to report an absence of 7 days or more for travel inside or outside of the country, as well as all dates and locations where they would stay during the trip. Importantly, child sexual offenders would also be required to do so for any trip, regardless of its duration.
Would also increase our knowledge of sexual offenders by authorizing the sharing of information on registered sexual offenders between National Sex Offender Registry officials and the Canada Border Services Agency. In particular, this would assist in preventing and addressing offenders who travel abroad to commit sexual offenses against children. C26 also proposes to create a national, publicly accessible database of high-risk child sexual offenders who have been the subject of a public notification in a provincial or territorial jurisdiction. A centralized database would help to ensure that law enforcement and the public have greater access to information about high-risk child sex offenders. Mr. Speaker, our government recognizes that the issue of child sexual exploitation is not one-dimensional and requires a multi-pronged or holistic approach. Although the criminal law reforms proposed in Bill C26 are a critical part of the overall response, I'm pleased that our government has dedicated over $10 million since 2010 for 21 new or enhanced child advocacy centers to address the needs of child and youth victims of crime and assist with the recovery of victims who have suffered significant trauma as a result of those heinous crimes. The bill aims to further protect the most vulnerable members of our society, our children, from exploitation by providing measures designed to deter and denounce crimes of a sexual nature committed against them. The sentencing amendments proposed in this bill include mandatory consecutive sentences, which would ensure that in cases of multiple crimes, including in instances where offenses were committed against multiple victims, an offender will not receive what is commonly coined a sentence discount at the time that they are sentenced. Before describing the specifics of these amendments, allow me to provide some background with respect to the existing sentencing principles that are applicable to multiple offenses. I will then focus my remarks on the proposed amendments to the sentencing regime with respect to child sexual offenses. Generally, the Criminal Code provides that a court has the discretion to order that a term of imprisonment be served consecutively to any sentence the offender is already serving or to any other sentence of imprisonment the court imposes, whether it is a result of the non-payment of a fine or not. Mr. Speaker, if this provision sounds confusing, it is because it represents an amalgamation of sentencing rules that predate Confederation. Moreover, amendments over the years have further complicated the statement of the rules contained within the Criminal Code. In addition to these Criminal Code rules, case law offers guidance with respect to the circumstances in which consecutive or concurrent sentences are imposed on an offender. In general, courts will order that the sentence for two or more offenses arising out of one continuous criminal act or single transaction, also referred to as the same event or series of events rule, will be served concurrently, or if you prefer, simultaneously. In these cases, the offender will serve the longer of the sentences imposed. Offenses or multiple convictions that arise out of a separate criminal transaction generally will garner consecutive sentences which are served one after the other. The imposition of concurrent sentences for offenses committed as part of the same event or series of events usually reflects the fact that the guilty mind of the accused is the same throughout the event or events, as opposed to offenses arising out of separate criminal transactions. That said, courts will be reluctant to order that offenses committed as part of the same event or series of events be served concurrently when it would allow the offender to commit subsequent offenses with impunity, especially where the subsequent offense is particularly serious in nature. For example, courts will order consecutive terms of imprisonment for an offense, a first offense, that is committed while fleeing from the police, the second offense. They will also order that an offense committed while on bail will be served concurrently to the terms of imprisonment for the predicate offense, I should say. The determination of whether sentences are to be served concurrently or consecutively, therefore, is a matter of fact-specific inquiry. And that inquiry is as to whether the connection between the two offenses is sufficiently close to warrant concurrent sentences. Mr. Speaker, it is important to outline the relevant sentencing principles at play, especially when discussing concurrent and consecutive sentences. The Criminal Code provides that the fundamental purpose of sentencing is to contribute to the respect for the law and the maintenance of a just, peaceful, and safe society by imposing fit sentences that have one or more of the following objectives: denunciation, deterrence, separation of offenders from society, rehabilitation, reparation for harms done to victims, and the promotion of a sense of responsibility in offenders. A fit sentence is one that is proportionate to the gravity of the offense and the degree of responsibility of the offender. The Criminal Code explicitly directs that a fit sentence must focus on the objectives of deterrence and denunciation. The last step a court must take before deciding whether to consider that any terms of imprisonment that it imposes be served consecutively or concurrently is to consider the totality principle. Pursuant to paragraph 718.2c of the Criminal Code, a court that imposes consecutive sentences must determine whether the combined sentence is unduly long or harsh. In other words, the totality principle requires courts to determine whether the totality of the sentence adequately reflects the overall gravity of the offender's conduct. Where the court is of the opinion that the combined sentence is unduly long or harsh, it may order that some of the offense be served concurrently instead of consecutively. However, where the criminal code prescribes mandatory consecutive sentences, a court may impose shorter sentences on some or all of the individual offenses in order for the combined sentence to be a fit sentence. And this would be the case for the offenses of possession of explosives for a criminal organization, use of firearm in the commission of an offense, or terrorism offenses, or criminal organization offenses. In these cases, the criminal code requires judges to order that the term of imprisonment for these offenses be served consecutively to terms of imprisonment imposed for other offenses, whether they arise out of the same event or series of events or not. The proposed amendments clarify and codify the rules regarding the imposition of consecutive and concurrent sentences, which I outlined earlier in my remarks. The amendments would also require courts to order, in certain cases, consecutive sentences on offenders who commit certain sexual offenses against children. This would be similar to the current requirement of consecutive sentences for offenses that I mentioned earlier: terrorism, criminal organization offenses, use of a firearm. Specifically, the bill proposes that sentences for child pornography offenses be served consecutively to any sentence imposed at the same time for a contact child sexual offense. It would also propose that in cases of multiple victims, sentences imposed at the same time for contact child sexual offenses committed against one victim be served consecutively to those imposed for contact child sexual offenses against any other victim. These amendments recognize the increasing tendency of courts to direct that a sentence for possession or making of child pornography be served consecutively to a sentence for contact child sexual offense in recognition of the heinous nature of sexual offending against children, especially where the child pornography material is distributed via the internet. Furthermore, requiring child sexual offenders to serve sentences imposed for offenses committed against different victims consecutively would address the so-called volume discounts given to child sexual offenders sentenced at the same time for multiple child sexual offenses. This direction is also valid in cases of multiple child sexual offenses, especially where there is more than one victim. These proposed amendments will reinforce the continued efforts of this government to protect children against sexual offenders by ensuring that these crimes are denounced, the child predators are deterred, and every child victim counts. In closing, Mr. Speaker, I would encourage all members to support these important amendments that seek to protect our most vulnerable members of society, our young children. Thank you, Mr. Speaker.